Hello, powerful people. Welcome to this Power at Work blogcast. Thanks so much for joining us today. My name is Seth Harris. I'm a senior fellow at the Burns Center for Social Change. And man, we got a really good one for you today. We're going to analyze and break down and offer some opinions about the United States Supreme Court's recent decision in Glacier Northwest versus Teamsters Local 174. That decision was issued on June 1st. We recorded this introduction, but also the blogcast itself on June 6th in the early afternoon. There was a lot of heartburn about this case when the Supreme Court agreed to hear it. I would say it did not turn out as badly as some of the predictions suggested it might. That doesn't mean it isn't a terrible decision. It is. It is just an embarrassingly bad decision by the Supreme Court, both substantively and procedurally. You'll hear us talk about that shortly. Fortunately, I was able to recruit two absolutely top-notch lawyers and scholars and teachers to help me to explain and analyze this decision. Charlotte Garden is a professor of law at the University of Minnesota Law School. She is very widely published on labor law and other topics. She's active in a number of public policy initiatives and has testified before Congress about the PRO Act, among other things. She's widely acknowledged as one of the very best in our field. Anne-Marie Lofaso is the Arthur B. Hughes Professor of Law at West Virginia University College of Law. She's also been published extensively on labor law issues and other issues. She spent a decade as a senior attorney at the National Labor Relations Board in the appellate and Supreme Court branches. So she really knows both of those institutions, the NLRB and the Supreme Court, extremely well. And she knows how they make their decisions. So really worthwhile to have her in the conversation. But let me just say, even with those distinguished credentials, distinguished curricula vitae that our guests have for today, their most important credential is that together we wrote a casebook about private sector and public sector labor law. When I say together we wrote it, I'm really not giving them enough credit. They did the lion's share of the work. They sort of were nice enough to take me along for the ride and put my name on the book, but the credit really goes to them and our friend Joe Slater, a professor at the University of Toledo Law School, who's fantastic, and a couple of we've had other co-authors along the way. But they were the brains of the operation, and you're going to see that in this blogcast. Before we get started, I just want to talk a little bit about the Supreme Court and this case, because it's so hard. Even though I love talking about the law, former law professor, this blogcast gave me a chance to geek out with a couple of fellow travelers about labor law. But it's so hard to talk about Supreme Court decisions nowadays as though they are serious legal decisions rather than political decisions. And this case really is not going to help with that at all. As you're going to hear in our discussion on this blogcast, this is a case that did not need to be decided. It was a case that should have been dismissed, sent back to the state courts, if at all, remanded. And the decision itself is just a terrible decision, badly considered decision. It's part of a larger agenda at the Supreme Court. Part of it is an anti-worker, anti-union agenda, or what they would call a pro-business agenda. We certainly saw evidence of that about 5 years ago in the most famous of the bad decisions for worker power, Janus versus the American Federation of State, County, and Municipal Employees, which essentially made all of state and local collective bargaining law, right to work laws. Really another terrible decision. But in case after case after case, the court finds a way to support employers and to oppose workers and oppose unions. Now, unions win one every now and again. The American Federation of Government Employees won a case at the Supreme Court a few weeks ago having to do with whether or not they represented a group of workers that were part of the Ohio National Guard. a nice victory for them, but a fairly small case that doesn't have far-reaching implications in our society. I don't want to diminish it. I'm glad AFG won the case, but not as big a case as the one that was the Glacier Northwest case that we're going to discuss today. When they get the chance, this court tries to do damage to worker power in our society, and that is not their role. That is not their job. We often hear people on the right talk about activist courts. Well, we have an extreme activist court right now that is making decisions in a whole host of areas that are really dangerous for our society and are making a host of circumstances worse. Obviously, the Dobbs decision having to do with women's reproductive autonomy, a catastrophically bad decision by the court, and one that's going to damage women's role in our society and women's rights and women's autonomy in our society, but many, many, many others. And they're not, as Justice, and you'll hear me say this during the blogcast, but I want to say it again here, they're not behaving in a way that Justice Roberts promised they would behave, and that is humbly, where they're not deciding issues. They don't have to decide. Where they do take on an issue, they decide it very, very narrowly. They are seized by a real right-wing fervor, and that's a shame. A lot of us who grew up in law schools being taught by children of the Warren Court era were taught that courts were the saviors of individual rights, courts were the saviors of individual liberties. To the extent that that was ever true, it certainly wasn't true for very long. And courts have been problematic in the area of labor law for decades. It's not new. Employers have gone to courts, and courts have narrowed workers' rights, deprived workers of rights. It has long been the case. And this, unfortunately, is another chapter in that unfortunate story. So I wish I could leave you with good news. The good news is this case is not going to matter as much as we feared it might. But I really want to encourage you to listen closely to the analysis that we're going to get from Charlotte and Ann, genuine experts in this field. Ann lays out some legal advice, both for the board and for unions, about how to proceed, how to narrow this very bad decision, and to protect workers' right to strike, which is extraordinarily important to their ability to exercise power in our society. So I hope you enjoy this very interesting labor law discussion with Charlotte Garden and Anne-Marie Lofaso. So let me start by thanking both of you for being here and being here on fairly short notice. The court issued this decision just a few days ago, and I had to get my machete out and hack my way through this writing that I thought was just terrible. But we're here to talk about the Supreme Court's decision in Glacier Northwest versus Teamsters Local 174. We're recording this for everybody's information. We're recording this on June 6th. The decision came out June 1st. And as both of you know, there was a lot of nervousness about this case. Workers' right to strike. A lot of people felt workers' right to strike was at real risk in this case. The good news is that the right to strike survived, although we'll talk about how badly dinged up it is from this decision. So that's the good news. The bad news is this is just a terrible decision in a whole bunch of different ways, and we're going to talk about that as well. But there's a lot to unpack. In addition to the right to strike, the ostensible issue in the case is the extent to which federal labor law preempts various state laws. Beneath the surface, there's another issue, which is about a campaign that's underway among some of the justices on the Supreme Court to significantly weaken administrative and regulatory agencies like the National Labor Relations Board. So let me set up the conversation. I'll talk about like we were back in law school. I will give the facts of the case, and I'll do the same terrible job I'm here that I did back when I was in law school. And then our legal experts will tell us a little bit about what they think about what happened here. And let me just say one thing about the facts. And this is one of the frustrating things about reading this decision is that Justice Amy Coney Barrett, who wrote the majority opinion, based her decision on the facts as they were alleged in the complaint that was filed by the employer in the case. So these are not facts as established in a court of law or found by a trial court or by anybody else. This is what the employer in their complaint says happened. And so the facts are stilted in the employer's favor. in some of the writing of the decision, it's kind of hard to tell that, because she says that in the beginning, but then Justice Barrett writes it as though these were facts that were found conclusively by someone. I suspect the Teamsters have a different opinion of the facts than the complaint offers from the employer. But the case arises out of a strike by Teamsters Local 174 against Glacier Northwest. It began on August 11th, 2017. Glacier Northwest is a Washington State ready-mix concrete company, and the Teamster represents its truck drivers. The parties' contract was in the process of expiring over that summer. Perhaps it had expired before the strike started. According to the employer, the Teamsters timed their strike to maximize damage to the company. That's one of those facts I suspect the Teamsters don't agree with. On August 11th, Glacier mixed the concrete it was selling to its customers, loaded it up into those whirling concrete trucks, the ready mix trucks, I guess they're called, and then sent their drivers, the Teamsters, off to deliver the concrete to their customers. And that's after that happened is when the Teamsters commenced their strike. Now, the company alleges that it told the drivers to finish their deliveries, but that the union said, no, don't finish the deliveries, bring your trucks back to the facility. 16 drivers who had already left to do their deliveries brought their trucks back, I think fully loaded or almost fully loaded. Seven of them parked their trucks, didn't say anything to anybody, says the company, and either asked for instructions or took action, or didn't take any action to protect the trucks. Oh, I'm sorry. 7 did. They parked their trucks, they took instructions, and they gave and they helped out with making sure the trucks weren't damaged. 9 drivers did not do that. They just parked their trucks and they walked away. Again, that's the company's version of the events. Now, one of the most important facts in this case, of course, is that concrete hardens if it sits around long enough, if it dries particularly. So the employer alleges that this was all about the union trying to maximize the waste of the concrete, and also if the concrete had hardened in the trucks, it might have, almost certainly would have damaged the trucks. So the employer sued the union in state court using 2 state law torts claims. One was called conversion, the other is called trespass to chattels, sort of injury to property. The union argued that the tort claims were preempted by federal labor law, and you're gonna hear that phrase a lot, preempted by federal labor law. We're going to talk about that. All of the Washington state courts, including the Washington Supreme Court, said, yeah, we're preempted. We can't decide these tort claims, and they dismissed the tort claims. Now, there's a very important fact that I'm going to give to you right now, but then we're going to put to the side for just a minute. And that is that after the Washington Supreme Court said, yeah, we can't hear this case, it's preempted, the National Labor Relations Board's regional director and general counsel issued a complaint against the employer for an unfair labor practice of illegally retaliating against the striking drivers, including with this lawsuit. So it was the opinion of the prosecutors at the National Labor Relations Board that this was that the employer's reaction, its discipline of the employees and its lawsuit against the union was illegal retaliation under the National Labor Relations Act. Okay, so we're going to put that fact aside for a minute because it plays a very important role in the Supreme Court's decision, or doesn't, as the case may be. So Washington State Supreme Court decision gets appealed to the the U.S. Supreme Court issues a writ of certiorari to hear the case. They rule 8-1, agreeing with the employer that the state tort claims are not preempted. The only dissenting justice was Justice Ketanji Brown Jackson. Justices Kagan and Sotomayor joined Justice Barrett's majority opinion, along with Justice Kavanaugh and the Chief Justice. Justices Thomas Alito and Gorsuch separately concurred, and we will talk about them shortly. So, Anne, let's start with this. Let's help folks to understand why the state courts concluded that the employer and its torts claims were preempted by federal labor law. Help us to understand what preemption means and how it works.
Okay, so there's many different types of preemption, but in labor preemption, there's something called Garment preemption. And in Garmin preemption, if the conduct that is allegedly a tort, and a tort is some sort of harm that's non-contractual, so a non-contractual harm like alleged here, if something is if that is as a result of protected activity under the federal law, which is the National Labor Relations Act, then we have something called the Supremacy Clause. And the Supremacy Clause says that if something is protected by the National Labor Relations Act, or even arguably protected, then the then the National Labor Relations Board gets to decide what happens in the first instance, and it's completely preempted by it preempts the state courts from deciding that. And the reason we want that is because we want a national labor policy that is uniform across the entire country. We don't want to have different states having different ideas about what protected concerted activity is.
So, Charlotte, by the way, that was a really excellent and concise description of an incredibly complicated labor law concept. Preemption is a big concept, so good for you, Anne. I actually, it's funny because Anne did not learn that from me, even though I wrote the chapter of our casebook on preemption. I wish I was as concise as Anne had just been. But Charlotte, so labor law preemption is pretty controversial on the Supreme Court, and we know that from this decision, right? Thomas, Alito, and Gorsuch concurred in the decision specifically to talk about Garmin preemption. Right, and it's called Garmin preemption because that's the name of the case where it was announced by the Supreme Court many decades ago. So, tell us what I'm not asking you to channel Thomas, Gorsuch, and Alito. I think you'd have a little difficulty doing that. Tell us what their argument is. Tell us what they're trying to accomplish.
Yeah, so you can think about a conflict between federal law and state law in a few different ways. So one way state law and federal law might conflict would be if they tell somebody to do opposite things. So, imagine we've got, federal law that says you have to pay your workers at least $7.25 an hour, and some state adopted a law that said you're actually not allowed to do that. So that's a conflict, right? And a narrow way to think about preemption would be to say that it only applies when there's a direct conflict between state and federal law. Now, labor law is broader than that. Labor preemption is broader than that. And that's because the National Labor Relations Act was intended to displace state law, but also especially courts from adjudicating labor disputes, right? And that's because the context, right? So the National Labor Relations Act passed in the 1930s when courts were deciding cases in a way that was extraordinarily hostile to unions and to striking workers. And so Congress wanted to remove state courts, right? Remove federal courts as well, from dealing with strikes whenever possible. And so Congress created a federal agency, right, now known as the National Labor Relations Board, that would deal with labor disputes, right, and would decide when labor law had been broken by an employer and then eventually later or a union. And so labor preemption is about not just preventing conflicts, but also kind of preserving that structure where the federal agency and not courts decide the scope of labor laws protection for striking workers. So Justice Thomas's opinion suggests that he wants to revisit that rule, and that he might be interested in a rule that says that labor law would preempt state law only when there's a direct conflict. And so that would be a huge change. It would allow much more state court intervention in labor disputes.
Well, so I want to pick up on that. I want to stick with preemption for a minute. So just in the context of this decision, 3 justices signaled in their concurrences, Thomas, Alito, and Gorsuch signaled in their concurrences, hey, we want to reconsider this entire doctrine, as you were just saying. Plainly, the majority either doesn't agree with them or wasn't ready to go that way yet. And I don't want to say they're never going to go that way, but this could have been a case in which they made that change. And, maybe Kavanaugh, maybe Roberts, maybe Barrett were just like, not yet. We're not ready to do that yet. Or maybe they're never going to be ready to do it. It's very hard to know from this decision, at least. But let me say, labor law preemption is controversial not just among right-wing justices of the Supreme Court. It's also controversial among a lot of worker advocates and labor law scholars, progressive labor law scholars, because the perception that many of us have is that labor law is, as our one scholar put it, ossified. It is stuck in the mud. It has not developed. It has not been reformed by Congress in many, many, many years. And there hasn't been innovation at the state level because of labor law preemption. So let me ask both of you, and I'll start with you, Anne. Would it be a terrible thing if the Supreme Court narrowed preemption, at least narrowed garment preemption to the kind of category that Charlotte was talking about, where it only applies, there's only preemption where you have an actual conflict? Would that allow for the kind of innovation that some on the left are calling for?
It would in New York. It would further divide the country. You would see sort of like it would divide along the lines of right to work, I suspect. And so we've already seen that kind of innovation because the National Labor Relations Act expressly eliminates right to work from the preemption doctrine. So what you would have is you'd have more rights for workers in certain states, mostly in the North, the East, maybe the California, the coasts, and you'd have less in middle America and the South. And the problem with that is that I think people are forgetting their history. Why do we even have the National Labor Relations Act? We have it because when workers are disgruntled and they're oppressed, they go on strike, whether or not they have the right to strike. Exhibit A, West Virginia, that doesn't have the right to strike, and every county went on strike a few years ago. And that creates obstructions to commerce, which is bad for a capitalist country. So everyone got together, and the human rights people, which tended to be on the left, wanted this because they believed that people should be able to get together and help themselves, band together for mutual aid or protection, and to help themselves raise their working conditions. And the right said, wait, this is also good for capitalism. So I think the court actually is really forgetting history, or doesn't understand the history of our country.
Charlotte, what do you think? Are you a little bit more agreeable to narrowing the preemption doctrine and hope that maybe we'd get some innovation at the state level?
Well, I think if there were to be a decision that said garment preemption is no more and we're only interested in conflict preemption from here on out, then I think we'd see states with Democratic trifectas do things like increase the penalty.
Trifecta. By trifecta, you mean a Democratic governor and Democrats in control of both houses of the legislature.
Yes,
Sorry,
exactly.
Just a little. I'm going to do a Charlotte to English translation as we go.
Makes sense. Yeah. So we'd see these states do things like increase the penalties on employers that violate labor law. And I would really like to see the penalties for employers who violate labor law increased, right? As we're seeing in the context of union campaigns in places like Starbucks, it seems like many employers feel emboldened to violate workers' labor rights left, right, and center because the penalties under the National Labor Relations Act are extremely toothless. Employers think of this as just a cost of doing business. They're perfectly willing to violate labor law. So I would like to see that. However, I don't think for a second that this Supreme Court is going to say garment preemption is no more. States go forth and pass laws that will be beneficial to unions or beneficial to employers, whichever. I think this Supreme Court would find a way to change labor preemption in a way that would benefit employers and benefit states that want to constrain unions and constrain strikers without doing the opposite, right? Without enabling state legislatures to do more to protect striking workers.
Yeah, I wish I could say you're being cynical, but sometimes cynicism is the right approach to take. I'll just add this perspective to the analysis that you all just offered. The Thomas Alito and Gorsuch position is, to me, not just about trying to harm unions, which is definitely a part of their agenda, but it's also part of an anti-regulatory agenda, an agenda to undermine regulatory and administrative agencies like the NLRB. So the Supreme Court has a case on its docket called Loper Bright Enterprises versus Secretary of Commerce Raimondo, that it very likely will use to overturn the longstanding principle that courts are supposed to defer to regulatory agencies when those agencies are interpreting statutes that Congress has delegated authority to them to administer. So, for example, the Labor Department administers the federal minimum wage law. When the Labor Department interprets the federal minimum wage law, courts are supposed to defer. The Supreme Court, I'm quite confident in that case that the right-wing majority is going to say, no, courts should not have to defer any longer as an effort at weakening regulatory agencies. The court has signaled that it's looking for an opportunity to overturn another longstanding rule that courts have to defer to agencies when they're interpreting their own regulations. There was a move in that direction in a case called Kaiser versus Wilkie in 2019. The effort was held back, but the same three justices were very clear in that case that they would have absolutely wiped out that deference logic as well. And since Garmin preemption, as Anne explained it correctly, in my view, is largely about protecting the NLRB's role as the first decision maker in cases where there's arguably been a violation of labor law, I think the decision in this case is about taking authority away, it's partly about hurting unions, but it's also partly about taking authority away from the NLRB and putting it in the courts, because that part of the large project here is to empower courts at the expense of the other branches of government, including Congress, which is what they're doing here. This is Congress's authority that they're taking away, but they want courts making these decisions, not the NLRB. Okay, so that's my little rant about administrative law here. Let me get back to the majority opinion, Charlotte, and let me come back to you with this. So the majority's conclusion was the Glacier Northwest's torts claims, its two torts claims, were not preempted. How would you characterize the way Justice Barrett got to that result?
So it's a strange decision. You mentioned in your description of the case this critical fact that the National Labor Relations Board issued a complaint, right? So by the time the Supreme Court decided this case, proceedings in front of the National Labor Relations Board had been ongoing for some time. But one thing we know is that the National Labor Relations Board's prosecutorial arm had investigated the facts and decided based on its own investigation that there was at least cause to believe that the employer, not the union, had violated the National Labor Relations Act, right? It had done that by, among other things, issuing these disciplinary letters to the striking drivers. So once you've got an expert agency that's undertaken some investigation and decided, yeah, it looks like the employer did something wrong here, it seems completely nonsensical to say, on the other hand, we think that this case could proceed in state court for at least a little bit longer because the employer alleged something that could be read as a reason to believe the strikers lost the protection of the act. So there's this real inconsistency between what's going on in the state courts and what's going on at the board. So I think the right thing for the court to do would have been to say, we should never have taken this case. We should dismiss it, dismiss the writ of certiorari as improvidently granted. If it didn't want to do that, it could have done something called a grant vacate and remand, where it would have said, maybe we thought the Washington Supreme Court didn't do exactly the right thing when it dismissed the case and it should have stayed it instead, right? This is not the stuff of, Supreme Court opinions, right? This is sort of error correction, and the Supreme Court always says it's not in the business of error correction. So instead of doing those things, which I think would have made sense, the Supreme Court the majority decided to write an opinion that had to do with something called reasonable precautions. So there are a few board decisions out there that say that striking workers can—
You said board decisions, you mean decisions of the National Labor Relations Board. So basically Justice Barrett is relying on decisions by the National Labor Relations Board to tell us what labor law means, which you would think is the right thing. Whether or not those were the right cases for her to be citing is another question, but she, just so everybody understands, the people out there who are not in the cognoscenti of board experts, when you say board, the board issued decisions that laid down the law about when you can and when you can't strike, or what you can and can't do when you strike. I'm sorry, go ahead.
Yes, yeah. So the National Labor Relations Act broadly protects the right to strike, right? There's this narrow exception for situations where unions don't take reasonable precautions to protect employer facilities or people from imminent aggravated harm. These are decisions that are issued in situations where it's not just that the employer is going to lose perishable products because of the strike, right? These are situations that are extreme, where, the board recounts facts like there was, sort of molten iron or molten metal that was about to be poured off, and the strike created a risk that, the entire plant would burn down, or there's some kind of chemical process going on, and the strike creates a risk that there would be some kind of poisonous gas release, right? So not just something's going to, not just there's going to be a loss of concrete, right? Something more serious than that. So the union, I think correctly, in my view, said these cases don't apply. Yeah, maybe we timed our strike so that, there would be a loss of concrete, but that's not the kind of sort of aggravated imminent harm that these reasonable precautions cases are dealing with. So that's where Justice Barrett seemed to disagree. And, like you said earlier, she's relying on kind of the employer's recitation, right? The employer's view of what happened as, described in its complaint, rather than any kind of factual investigation. And she interprets this reasonable precaution standard to apply in more situations, right? And so that's part of the problem with this decision, right? That she suggests that the employer plausibly alleged that the union didn't take reasonable precautions, in part because, the employer alleges that, harm could have resulted to the trucks, but also, and even more disturbingly, because in Justice Barrett's view, the complaint alleged that the union kind of brought the perishable concrete into being when the workers showed up for work, and the employer sort of presumably thought they were going to work the full day. And so it mixed the concrete and loaded it into the trucks. So the court kind of decided to say something about this reasonable precaution standard, and then said, because the complaint fits under our new our new view of what kind of cases or, what kind of situations this reasonable precautions test might apply to, right, that the employer gets to stay in state court for now.
Well, so I want to pick up on that, Anne, because this decision read to me like a trial court decision almost. She's very carefully parsing facts. By she, I mean Justice Barrett. She's applying existing precedent to those facts. What Charlotte is hinting at is that maybe there's some new law here. Is there new law made by this decision? Do we now have a rule in labor law that if you both go to work and somehow inspire your employer to take an action, and then you strike in a way that's going to create not just spoilage, but potentially substantial property damage to the trucks because the concrete might have hardened in the trucks, and you don't take reasonable precautions to undertake that, is that the entirety of what this case says? I'm genuinely confused about what happened here. What's your sense? Because you were in the Supreme Court and Appellate Division at the National Labor Relations Board. If you were going to try to interpret this for the General Counsel, what would you even say?
Well, I would say that this is the advice I would give to unions or to the General Counsel, that that's not what it says. That what it says, and that's not to suggest that Charlotte's analysis is wrong or anything like that. This is how I would do it as a lawyer. That's not what it says. What it says is that that first of all, that Justice Barrett cherry-picked her facts and said these are the facts most favorable to the employer. The employer alleged that that the union caused the goods, meaning the concrete, it created the situation that would lead to the so-called perishable goods to rot. It actually left intact all the perishable food cases, and it also said it was interpreting.
Just clarify that when you say the perishable food cases, explain what you mean by that.
Okay, so there's a line of cases that says that if you go on strike in, say, a supermarket, and after a while, some of the food could perish because there's no one to tend to the food, that's incidental to a strike. The union wanted to use that line of cases to say here that this was just incidental to the strike. And it may very well win that at the state court level. That's the other thing I would say to the General Counsel, is there's two things going on now. Now this is remanded to the Washington state court. So there's potentially going to be a trial on that, and they get to say, no, those are not the facts. And as Justice Barrett made very, very clear throughout in the opinion and also in a footnote, that this is just taking the facts in the light most favorable to the employer. The employer has to prove these facts, just like the union has to prove its facts. So that's the first thing I would say. The next thing I would say is, look at the brief we wrote, meaning the government. I would say this to General Counsel. We were the ones who raised this entire doctrine, and they picked up on that doctrine. So the government actually raised this doctrine and said, that there's this doctrine about reasonable precautions. And I think the government took a risk here, and a calculated risk, saying they didn't want to get rid of strikes. And they said they tried to shoehorn this into the reasonable precautions. Then I would say also that this is a very narrow decision, that it is that only in situations where you have something that can create that, where the union actually creates the situation that creates the so-called perishability of the good that is intentionally going to harm the employer, does this case apply? And so the job now of unions is to actually narrow this case as much as possible, which is possible. Employers are going to come back and they're going to say, no, 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 we're going to punch a hole right into the right to strike here. At the same time that those two forces are going on, as you know, Seth, the government changes and oscillates between different policies depending on whether Republicans or Democrats win.
Can I say I haven't noticed that?
You haven't noticed? I know, it's really hard to notice.
I'm not sure I understand what you're talking about. You're saying that Republican National Labor Relations Board majorities and Democratic don't vote exactly? I'm outraged. I can't believe you're talk about cynicism. Oh my goodness.
Well, and as you know, words do have stretch in them, and the Democrats stretch the words to what I see as an enforcement mechanism. They're trying to enforce the National Labor Relations Act, and Republicans that are very pro-business or anti-union, more anti-union than pro-business, because I would suggest that being pro-union is pro-business because it helps everyone. but being anti-union would actually stretches the words to I think to its breaking point often, at least lately, and that's definitely one of the problems that's going on here. So I agree also that something that you said, Seth, that was really, really important. Um, there is definitely at least a minority on the court right now that wants to get rid of the administrative state. Now, one of the problems is that there are cases called pre-Chevron Chevron cases. That's what I like to call them. So Chevron is the doctrine that gives deference to these agencies. The courts aren't allowed to second guess agency decisions that are interpreting ambiguous parts of the statute that that Congress charged it with administering. So here the National Labor Relations Act had that kind of deference before the I think it was 84, maybe it's 86, it's in the mid 80s though, Chevron case. It was doing that almost from the very beginning, from 1935 on. You see that the courts are giving deference. So the problem is that if the court wants to get rid of Chevron, it can't just get rid of Chevron. It has to actually say, oh, and by the way, for 50 years before that, we were egregiously wrong. Now, I think it has a problem if it does that, because as I always tell my students, if you're a textualist, you're not a liberal or a conservative. A textualist takes the text of the statute for what it's worth. And so if that's a radical liberal statute, then that textual words are radical liberal. Professor Carl Clare said that the National Labor Relations Act was the most radical statute of its time. If you look at the text of the National Labor Relations Act, it has been interpreted and diluted toward a more conservative manner. If I were unions, I'd start making textualist arguments, and I would also bring in the purpose through the text. 29 USC 151. That is the section 1 of the act. That is text, and it states what Congress's purpose was: to encourage the practice and procedure of collective bargaining. Everything has to go within that. It is text, and I would hammer that in. Now, what Charlotte was saying is a very strong possibility, however, which is why I think Charlotte's view is cynical and potentially correct, because what she's saying is, hey, this is how this is going to be interpreted. And this is certainly, I think that's exactly what employers are going to do. And there's going to be a fight now. And that's why elections matter.
Yeah, well, that's absolutely right. I do want to make I think I really appreciate your raising textualism. Textualism is, of course, a philosophy mostly advanced by justices on the right. It was originally introduced into the Supreme Court jurisprudence by Justice Antonin Scalia. And the logic of textualism is the words that are in the statute are the only thing that are law, not the intent of Congress or the purpose for which Congress enacted a law. It's only the words. Well, there is an express provision of the National Labor Relations Act, which I did not see cited anywhere in Justice Barrett's majority opinion. I may have missed it. I read it maybe more quickly than I should have. You really have to tear these things apart. But there's an explicit provision that says, I can't give the exact quote, but it essentially says nothing should be permitted to interfere with a worker's right to strike. So a strict textualist reading, I believe it's section 13 of the act, do I have that right, would say, oh, this reasonable expectations thing is in derogation of the text of the statute. It's all made up, and therefore it has no bearing on the case. This was a strike. Strikes happen. Strikes are about damaging employers. Congress knew that that was the case. Strikes had been happening for many years before the National Labor Relations Act was passed. If strikes cause harm, that's the way it is. Congress knew it. We may not like it. We're the Supreme Court, but we're not supposed to get into that. We're not the lawmakers. Congress is the lawmakers. Didn't see anything like that in any of the decisions, any of the opinions.
And if I can add that, in fact, two things. One is that's exactly how I would have written the brief. Exactly what you said is how I would have written the brief, as not for the government, or I would have written that for the union. But I also think Barrett, then what I found really strange and anti-textualist was when Barrett then says, but there are limits on the right to strike. And one is this doctrine. well, maybe the doctrine shouldn't have gotten Chevron deference.
Right, exactly right. And there's no ideological consistency. I think that's one of the big frustrations about this decision is textualism is a tool they like to deploy when they can damage regulatory protections or damage workers or damage consumers. But when it comes to protecting the right to strike, and Congress has been absolutely explicit about the importance of the right to strike, the Supreme Court itself has undermined the right to strike in a whole bunch of ways, including going back to the 1930s when they said that permanently replacing striking workers is not a violation of Section 13 of the Act. So I don't want to get us too far off the path. Let me just, I want to pick up on a point that Charlotte made that's very, very, I think, an extremely important one. And this is one of the reasons why I thought this was just a terrible decision. When Justice Roberts was in front of the Senate Judiciary Committee for his confirmation hearing, he talked about being humble, the importance of judges and justices being humble about the law. Well, a humble Supreme Court would not have decided this case, and I think Charlotte made that case very, very effectively. They had an out. The board, at least the general counsel, had spoken. As Justice Jackson said in her dissent, there is no argument, there's absolutely no argument that when the general counsel's office has issued a complaint that there's an unfair labor practice at play in a case, that the conduct at play is arguably protected or arguably prohibited by the National Labor Relations Act. You can't make that argument. And what Justice Jackson, what Justice Barrett did, and let me just say, that's not an arguable conflict. That's not Garment preemption. That's an actual conflict between state law and federal law. So that even meets the standard of the three right-wing justices who only want an actual conflict standard. So there's a conflict here. What I thought was so disingenuous and upsetting about this decision is that Justice Barrett drops a footnote. It's footnote 3 in the decision, where she says, with respect to this inconvenient fact, let's call it, that the lower courts have not addressed the significance of any of the board's complaint with respect to garment preemption. We will not do so in the first instance. We're a court of review, not a first view. The board's general counsel agrees that this issue is not properly before us. Now, it's not in the case, because it was raised after the case, but it is a legitimate basis for saying, hey, wait a minute, we definitely should not be hearing this case. What's going to happen, in my view, and you were suggesting that what's going to happen is that it's going to end up in front of the state courts and then they're going to litigate the facts of the case. I don't think that's what's going to happen. With respect, you're much more expert at this than I am. I think what's going to happen is they're going to end up back in the Supreme Court. Or they'll end up in the Washington State Supreme Court or in a state trial court, and they're going to submit this ULP complaint from the general counsel. And I believe there may already be an ALJ decision in the case. I may be wrong about that. And they're going to say, hey, it's preempted. And the courts are again going to say, yeah, it's preempted because the NLRB is now in the game. They have asserted themselves. This is an actual conflict. We don't have to rely on garment preemption here. And it will have been a total waste of time. The Supreme Court did not have to decide this case. They should not have decided this case. Now, it's not like they're so busy. They only have 59 cases on their docket. Half of them are vacationing half the time. But I wanted to ask you, as we sort of move towards a close in the conversation, let me ask both of you this. I'll start with you, Anne. Given this fact that gave them an out, why were they so fixated on deciding this case? Why did the Supreme Court the majority feel it had to decide this case?
I have a couple of theories on that. First, I think they were mildly annoyed at the NLRB because it only issued the complaint after the Washington State Court was already done. And so it wanted to sort of decide the case as if the NLRB hadn't issued that complaint. It even suggests that it sort of forgets about that fact. And Justice Jackson, who really understands labor law, explains all of this. So I think that was one of them. Another one is I do think it wanted to kind of stake out certain territory, which is what you were suggesting earlier about the about where it sees administrative law going. I also think, but it couldn't get the votes. It only had 3 votes. But this also goes to why maybe 2 of the liberals created the majority. Okay, which is that they could influence the majority opinion. So it doesn't really matter whether this is 6-3 or 8-1. Justice Jackson could do the dissent. 2 others could go into the majority and make sure that this is written very narrow. So there are parts of that decision that unions can use to narrow it. There are parts that employers can use to try to open this up. I do agree that what you're saying is that there's a very strong possibility about the preemption also happening, and meaning they'll go to the Supreme Court again through the board case. And I also think that there's a possibility that the state court will say, wait a second, I want to see what the board says, we're just going to hold off. In fact, Justice Jackson suggests that in her dissent, and then Alito gets angry. You can read the anger in his decision, which I always think is a bad sign when you can read emotion like that in a decision, because it suggests that the justice is not thinking logically. So you can see that the justice basically says, if that happens, you better bring it back over here, as if that justice, no one else signs on to his concurrence. So as if he has the power to change all of this. That to me was the scariest part of the decision, frankly. So those are my basic thoughts about what was going on in response to your question.
Yeah, I love your comment about Justice Alito. I think if Justice Alito weren't angry, he wouldn't have much of a judicial philosophy at all. He is angry a lot of the time, and we've seen a number of decisions recently where he is just saying he's saying things in writing with his name attached to them that are imprudent, that are not appropriate judicial conduct. In one case, he accused the Biden administration of planning to not abide by the law, which is an outrageous thing for a justice of the Supreme Court to say. And for him to declare that the case has to come back to us if anybody should decide it in any way that's inconsistent with his decision. Well, that's not how things work in this system. Although I expect that what he's doing is inviting the employer to litigate this case as long as it can possibly do it, because delay generally benefits the employer in labor relations, particularly when there's a strike, particularly when there's a contract issue at play. Charlotte, what do you think? Why did the court feel it had to decide this case? And I want to pick up on Anne's point. It was a little bit jarring to see Justice Kagan and Justice Sotomayor in the majority on an anti-union decision. So give us the general question of why do you think the court felt it had to take on this case and finally decide it, and talk a little bit about those 2 justices.
Well, I think it's, so the first thing I noticed about this case was that the employer was represented by Noel Francisco, right? Who had been Solicitor General in the Trump administration, and also who had represented another Washington State employer in another Supreme Court case called Noel Canning, which was about the scope of the president's recess appointment power. So I think, when I see a labor law case with Noel Francisco representing the employer, I immediately think, well, this is a case that, the kind of conservative legal movement thinks can be used to weaken unions, to weaken administrative law, right? Weaken the power of administrative agencies. And so I think that's probably what caught the interest of the justices who voted to grant cert in this case to begin with, and potentially what held their interest to decide their case despite the unfolding facts and the board's complaint in this case. I agree with Anne about the likely meaning of Justices Kagan and Sotomayor's joining the majority. It's it seems, I think the court knows that it's under a lot of scrutiny right now, right? A lot of deserved scrutiny, both because of its substantive decisions in cases like Dobbs, the abortion case, and because of things like, the allegations about justice.
Corruption. You could say it. A corrupt justice is taking money from people who have cases in front of the court. It's okay to call it that. That's what it is.
Yeah. And so, I think Chief Justice Roberts is on a mission to preserve the court's power, right? And he wants to do that by issuing decisions where he thinks he can, that don't seem like they divide along ideological lines. So I think for him, it's a win in kind of a long-term strategic way to have a decision that is 8-1 rather than 6-3. And for the more liberal justices, right, that presents an opportunity to make the substance of the decisions less bad, right, to temper the substance of the decision. So I think that's, my gut instinct is that's kind of the brokered, kind of deal here almost.
Yeah, I think I would tweak. I think that analysis is right. I think both of you are right in that regard. And Justice Kagan has certainly been brilliantly strategic in the way she has deployed her vote and sometimes brought along one or more of the other more progressive justices. And she has been able to temper a bunch of decisions. For example, the Kaiser versus Wilkie decision about deference to administrative agencies that I mentioned earlier. She wrote the majority opinion there, but crafted it very, very carefully to make sure that she kept a majority for her position. But I worry that an 8-1 decision, even if it's a very, very narrow decision, has an immense amount of force. I think the vote actually does matter. I think that Sotomayor and Kagan voting with Justice Barrett and Justice Kavanaugh and the Chief Justice makes a lot of sense if it's a way to get a narrow decision rather than a decision that went the way of Thomas Alito and Gorsuch, which would have destroyed Garmin preemption. So that strategically, that makes a lot of sense. But one way to weaken a decision is to have it be I guess you would have had a 3-3-3 split, right? You would have had 6 in the majority, but 3 concurring saying kill Garmin preemption, 3 in the majority with this terrible decision, and 3 following Justice Jackson's dissent. And then you can say, well, it's a divided court and it's very hard to know what the right answer is here. And so this is sort of not so much a precedent. Now, I'm not sure it would have played out that way. It's, we'll only know in a few years as these various cases that you both have predicted, and I agree with that prediction completely, those cases are brought in state courts all around the country as employers try to put this case to use to weaken unions. I think the real danger here is not that employers will win cases in state courts. I think the bigger risk is that they will bring them as another tool to harass unions and to try to deprive their workers of the right to strike. So I predict we're going to see huge numbers of cases come up whenever there is a private sector strike in the United States. Maybe not every strike, but a lot of strikes, particularly the more contentious strikes. Employers will deploy this as a weapon. The board is not going to be able to intervene in every single one of those cases. The board is already grossly under-resourced, sadly under-resourced, even though it got a nice bump in the most recent appropriations deal. But I worry about that because the law has been used, courts have been used, as Charlotte said back in the 30s, but it's certainly been true even since the act has been passed. The courts have been used to narrow workers' rights, to deprive workers of their rights, to take away the potency of workers' rights under the National Labor Relations Act. And what the court said is not throw open the courthouse doors, but hey, employers, take a shot over there. See if you can't slow this thing down a little bit. Maybe you can destroy the organizing drive, or you can weaken the strike, or you can do any kind of delay that you can accomplish will get it done. And so that's my big worry coming out of this decision. I don't think the right to strike was destroyed by this decision. It could have been, even though I don't think that was the main target, but it's a disturbing decision on a lot of grounds. As a lawyer who really respects courts, I think that this was an unjustifiably bad decision, poorly written, poorly reasoned. It didn't have to be issued. But also, I think it's bad for workers and worker power in our country. And I hate to end on a down note because you two are fantastic guests. And I'm so, first of all, I'm really proud to be able to call you my friends. And I'm so delighted that you were able to join the Blogcast on very, very short notice. Let me just say, if one of the easiest ways to get people to come on a Blogcast is to call an academic during the summertime, right? They're not doing anything. Maybe they're writing something. Maybe. I don't know. Probably you are. Maybe we should have you on when you finish whatever you're working on right now. But I'm really grateful you came on this time to help us to understand Glacier Northwest versus Teamsters Local 174. And Charlotte, really appreciate you. Thanks a lot. Hey, thanks for hanging around after the Blogcast. How about that conversation, right? It made me a lot smarter. I hope it helped you as well. I really hope that you'll subscribe to the Power at Work blog. It's easy. You can just click on the subscribe button on the main page of the blog. You can also follow us on social media at Power at Work blog on Twitter, at Power at Work blog on Instagram, and on LinkedIn. Follow the Power at Work page. Just search Power at Work and our page will pop up. Follow us there. All of these tools, subscribing, following us on social media, will allow us to keep you informed about what we have new on the blog, what we have posted for you, what writings, what pictures, what podcasts that we have posted here on the blog. If you subscribe, the good news is, in addition to being kept up to date, you will get the weekly download delivered to your inbox every week. We're doing it on Fridays right now. We think that's working pretty well. The weekly download is a collection of a couple of dozen terrific stories, studies, analyses, think pieces from all over, videos, other information from all over the World Wide Web about workers and unions and worker power. We gather it together for you and then we send it to you into your inbox. If you are not a subscriber and you want to see the weekly download, it's available for you on the blog homepage. So go to poweratwork.us, subscribe. If you don't want to subscribe, check out some of the great content we have there. Thanks a lot for watching. We'll see you back here on the blog again very soon.